I'm now delighted to be able to introduce to you Michael O'Brien QC, who will give his presentation as well from the legal perspectives of the report.
Thank you, Anne, and also good afternoon, ladies and gentlemen. As Ian discussed, the Competition Policy Review examined and made recommendations for reform of Australia's competition policies, the laws and the institutions. Fortunately, in Australia, there's a broad consensus that competition in the production and delivery of goods and services is beneficial, great benefit to consumers, but also to businesses, providing them with opportunities to compete. And it's in that context that review and reform of Australia's competition law is important. It's important that there's balance in our competition law. It's important that the law doesn't impede competitive activity because to do so would deprive consumers of the benefits of competition. But it's also important that the law deters anti-competitive behaviour because of the need to foster rivalry and new entry. The panel challenged itself with a series of questions about the law. It asked itself whether the law was properly focused on enhancing consumer welfare over the long term. It asked itself whether the law was protecting competition or protecting competitors. It asked itself that critical question about striking the balance, whether we've got the balance right between prohibiting anti-competitive conduct while at the same time not interfering with efficiency, innovation, entrepreneurship. And we asked ourselves the very hard question for any law reform, is the law simple, clear and predictable, particularly in this area? And the overall conclusion that we came to was that the existing law has a sound framework. Our starting point, like with Hilmer, was that competition law ought to have an economy-wide application. And by and large, that is the case with our competition law. There were three principal exceptions to that, which are covered in the report. And the three exceptions are this: the price signalling laws that were introduced only a few years ago in Division 1A only apply to the banking sector. Section 51.3 that provides an exemption from the competition laws to intellectual property licensing was the second one. The third was Part 10, which provides a special regime for international liner shipping. And essentially the final report recommends removing the sector-specific exemptions and sector-specific laws to return to a more universal application of our competition law. The panel also considered the per se prohibitions, and the view that we took to that was that those prohibitions should be confined to conduct that is anti-competitive in almost all circumstances. In other words, they oughtn't to overreach in that way. And generally that's the case, but there were some problems that we've identified in the final report. There's some problems we felt with the cartel laws and certain exemptions that were too narrowly drawn. Again, there was a problem we thought with the price signalling laws and certain aspects of the per se prohibitions there, and also the third line forcing prohibition. I'll return to a couple of those. The panel endorsed the public and private enforcement regime that exists under our existing law, and also broadly endorsed the exemption framework that exists under our law that enables businesses to gain exemption from the laws on public benefit grounds. But having said all of that, with the sound framework, one of the overarching themes in the final report is simplification. And the reason for that is the panel reached the conclusion that over the years, unnecessary technicality had been introduced into our law, unnecessary prescription. And the report recommends quite a lot of simplification of Part 4 of the Competition and Consumer Act, to remove redundant provisions, to reframe many prohibitions, to remove the unnecessary technicalities, and to remove other barriers to the application of the law. And I want to provide a few comments on the main areas of reform in that regard. It won't have escaped your notice that the topic that has generated perhaps most controversy in terms of recommendations about the law is Section 46, misuse of market power, and that reform to Section 46 has been a topic of debate not only for the 12 months of our review, but I think it's been a topic of debate for nigh on 20 or 30 years now through many processes of reform. I don't think Section 46 is the most important issue in our report, and perhaps not the most important issue even in the area of competition law reform, but it does have some importance, particularly in an economy like Australia, which is marked by concentrated markets, and with many firms displaying aspects of market power. It's a matter of considerable public interest, so I'm going to start with Section 46, but I don't want the fact of my starting with Section 46 to be taken as indicating that I think it is more important than other areas. It's simply the fact that other areas enjoy broader consensus than the reform to Section 46. So let me start there. The final report proposes that Section 46 be altered to prohibit conduct by a firm with market power, substantial market power, that has the purpose or likely effect of substantially lessening competition. The proposed reform replaces two tests with one test. Currently there are two tests. There's a test of taking advantage of market power and a purpose test, a purpose of harming competitors. And they're to be replaced with the single test that we know as the SLC test, the substantial lessening of competition test. The final report also proposes that some legislative guidance be introduced into the section. And the object of the guidance is to minimise the risk of over-capture of the law. And the recommendation is that the section should direct the court to have regard to the pro-competitive aspects of conduct, such as enhancing efficiency, innovation, product quality or price competitiveness, and also the anti-competitive aspects of the conduct, such as restricting or deterring potential for competitive conduct or new entry. The opponents of the proposed reform are reasonably vocal. The stated arguments against the reform tend to be complementary, that the proposed law would be too uncertain in its application, and with the consequence that it would chill competition. Of course, there is an unstated premise that underlies that argument. And the unstated premise is that the current law is certain in its application, or at least more certain than the proposed reform. And secondly, that the current law is working effectively to curb anti-competitive conduct. And in its work and in its consultations, the panel considered both the stated objections to the reform and the unstated premise. Let me address them in reverse order. Let me start with the current law and the take advantage limb and offer a few remarks about that. It is the case that the opponents of reform don't discuss the current law and particularly the take advantage limb in the discussions. But this aspect of the current law really is the central element of our current law of Section 46. And there are two problems with the take advantage limb. The first, it's been very difficult to apply in practice. Section 46 cases have been to the High Court on 5 occasions now. Queensland Wire, Melway, Boral, Rural Press and NT Power. And if you survey the first instance, full court and High Court judgments in those 5 cases that have made their way right through the appellate system, all the judgments display a wide range of approaches to the take advantage limb of Section 46. And the difficulties of the interpretation, I think, are illustrated by the insertion of subsection 6 capital A after the Rural Press decision, which inserted 4 possible meanings of take advantage that you can choose from in trying to prove your take advantage case in Section 46 that are up there. But perhaps even more importantly than the difficulties of application of the take advantage limb, the panel reached the conclusion that the inquiry that's required by those words is misdirected. Section 46 is based on the premise that conduct undertaken by a firm with market power shouldn't be prohibited if the same conduct can and is engaged in by firms without market power. However, we know that various forms of commercial conduct are competitively benign when undertaken by firms without market power and are engaged in by firms without market power to try and achieve efficiency improvements, but can have anti-competitive exclusionary effects when engaged in by a firm with market power. And that's reflected in an often quoted statement of Justice Scalia in the US Supreme Court in the Eastman Kodak decision, where His Honour said that where a defendant maintains substantial market power, has substantial market power, his or her activities are examined through a special lens. And behaviour that might not otherwise be of concern to antitrust laws or that might even be viewed as pro-competitive can take on exclusionary connotations when practised by a monopolist. So the fundamental rationale for the take advantage limb is not as safe. There's also a lot of debate about the purpose limb in the current law. The opponents of reform prefer the current purpose test that's in the law and prefer it to an effects test. The conclusion that the panel reached was that the purpose limb in the current law was directed at the wrong issue and was wrong in two ways. It was wrong first because unlike every other prohibition in Part 4 of the Competition and Consumer Act, Section 46 uses languages of having a purpose of harming a competitor, not even the purpose of harming competition. And the language is up there for you to see. Harm to competitors, of course, is the expected outcome of competitive rivalry. And it's for that reason that competition law should always be directed at harm to competition, the competitive process, and not harm to individual competitors. But more significantly, the panel reached the view that competition law ought to strike at conduct that has the effect of harming competition, not the effect of harming a competitor. As I say, that's the outcome of competition, but the effect of harming the process of competition. The conclusion the panel reached was that the current law was defective in significant ways and could be improved. And for that reason recommended the insertion of the SLC test. Now turning to the stated arguments of opposition to the reform, that it's uncertain and will chill competition. The panel disagrees with that view and expressed the reasons for it in the final report, and they can be summarised in this way: that first, with respect to certainty or uncertainty, the SLC test that we propose is of course exactly the same test that you'll find in sections 45 and 47 and also in section 50 dealing with mergers, save that section 50 only has an effects test and doesn't have a purpose test as well. Second, there's no relevant distinction between the application of the SLC test in sections 45, 47 and 50 and the application of that test in section 46. True it is that sections 45, 47 and 50 deal only with multilateral conduct, contracts, trading terms, mergers, while section 46 includes both multilateral conduct as well as unilateral conduct. But that's a distinction without a difference. Most business decisions involve multilateral conduct. For example, loyalty programs that are engaged in by large corporations are multilateral in character because they involve the trading terms between the corporation and consumers. Loyalty programs are examined today under sections 45 and 47, and they're examined by a substantial lessening of competition test, and that test is applied satisfactorily by business lawyers and the courts today in that context. And indeed, the vast range of business trading decisions are multilateral in nature and are subject to the SLC test. Taking to the third point, the proper application of the SLC test under our competition law, which, as I say, occurs to most business decisions today, ought not to chill pro-competitive conduct. The proper application of the law requires an assessment of the impact of the conduct in question upon the competitive process. And I think we can say with some degree of confidence that conduct that improves efficiency, that enhances innovation or product quality, is pro-competitive in character, not anti-competitive, even if the corporation succeeds in winning a large part of the market. Our jurisprudence, our case law on the SLC test, going right back to QCMA in 1976, establishes those principles as foundational of our competition law, and in my view, I think we can have a great deal of confidence in the application of that law. Let me move on from 46. I've probably spent a little bit too much time on it, but it is the one of the greatest controversy. In contrast, the recommended reforms to cartel conduct seem broadly accepted. The final report makes four main recommendations for reform. First is to simplify the law. They're not that old, but they are very complex. The remodelled provisions that we've put into the annexure to our final report are a mixture of earlier and simpler Australian law, for those who are familiar with the old sections 45 capital A and the like, as well as provisions of a draft bill in New Zealand, which is also proposing a cartel law. So you'll see there's a bit of a mixture there. The second recommendation is to confine the cartel conduct prohibition to conduct that has some connection with Australia. You might be surprised to learn that there isn't a connecting factor in our cartel law with the trade of goods and services to, from or in Australia. We propose the insertion of such a limitation. We propose also the broadening of exclusions for joint ventures in particular, and to some extent for vertical restrictions as well. Those issues have been the subject of a great deal of criticism over the last few years and the subject of many submissions that we received. And we also propose getting rid of the prohibition on exclusionary provisions in Section 4D as being redundant, that a properly framed cartel law shouldn't need Section 4D and oughtn't to have that sort of duplication. We also recommend the repeal of the price signalling laws, even though they're not terribly old. They're only introduced a few years ago and are contained in Division 1A. The conclusion we reach is that Division 1A fail the criteria that we established for assessing the law. That's not to say that price signalling isn't a competition law problem, but the conclusion of the report is that price signalling can and should be addressed under Section 45. We have made one recommendation that has been a little bit controversial in some areas, which is to expand Section 45 to introduce a notion of concerted practices, which exists in the law in Europe in particular, to expand the notion of understanding to concerted practices. We feel that that's a sensible incremental expansion of Section 45 and can cater for circumstances dealing with exchanges of prices and the like between competitors. Now, I've realised that I've spent too long on Section 45 and gone a little bit over time, so is that fine? I'm going to just very briefly give, in a couple of minutes, an overview of some of our other recommendations. Third line forcing has been under the microscope for a long time. Many reviews have recommended that it no longer be a per se prohibition. We've joined that line, and we're hoping now that we've got universal support for that position and that will be changed. We propose getting rid of exclusive dealing Section 47 altogether on the assumption that Section 46 will be amended, because with the amendment to Section 46 you won't need a Section 47 vertical provision any longer. 45 can do the trick in combination with 46. And with resale price maintenance, we propose allowing notification. We haven't recommended removing per se from resale price maintenance, even though in some parts of America the per se prohibition has gone. We think it's too soon to make that change. The most significant change on mergers is that we're proposing to come up to have a new formal clearance process. A formal exemption process should be. And this has a few parts, but the most significant aspect to it is a proposal to combine the clearance and authorisation processes. For those who work in mergers, you'll be familiar that under a clearance process, you can go to the ACCC and persuade the ACCC that your merger does not substantially lessen competition. And under an authorisation process, you can apply to the Competition Tribunal and persuade them that your merger has public benefits. Through submissions and through consultation, we reached the view that it would make a lot of sense to be able to go to the one place and argue both points as need be, that your merger doesn't substantially lessen competition, but if it does, there are countervailing public benefits. And we propose that that be taken to the ACCC. I've really only touched on a fairly wide-ranging number of reforms. Can I mention 4 or 5 other ones? We think that Part 4 ought to apply fairly broadly to government activity engaged in trade or commerce, not only to government businesses, which is the current test. We propose removing limitations on the extraterritorial application of the law. Perhaps somewhat controversially, but importantly, we propose the removal of the intellectual property licensing exemption in section 51.3, and I've spoken about part 10 a little bit earlier on. And we also propose some simplification for the exemption processes and to empower the ACCC to issue block exemptions, again, akin to what can occur in Europe, which empowers the ACCC to effectively declare a certain class of business conduct as outside of the competition laws, which we think could be convenient, particularly in small business areas and areas that might be of concern for small business, to avoid the need for separate exemption processes. Can I conclude by saying this talk really is only an introduction to the reforms discussed in the report, because there are other reforms as well. The issues are discussed in greater depth in the report. If you practice in this area or have an interest in competition law, can I commend the report to you and encourage you to read the report. Thank you very much.
Can I thank you very much, Michael, for again, a very stimulating presentation of extremely complex material, as you say. I mean, both of the talks we have heard, we really require a great deal more time to come to grips with the complexity of all of the issues.